Present.
Jarek.
Present.
Rep. Giarrusso.
Present.
Rep. Ruggiero.
Present.
Ms. Jones. Mr. Frye.
Present.
Mr. Kane.
Present. We do have a quorum. We do have a busy week this week. We have a meeting today, and we also have a meeting on Thursday. We're going to try and wrap up our testimony of the commission by Thursday, and hopefully work on getting a report out a couple days thereafter. The first witness we'll call this afternoon is Pablo Rodriguez. Good afternoon and welcome.
Good afternoon. There you go. Good afternoon, members of the Commission. I'm Dr. Pablo Rodriguez. I'm former medical director of Planned Parenthood, and I am also a spokesperson for the Citizens for Responsible Government, which is a coalition of civil, reproductive, and workers' rights opposing the establishment of a constitutional convention. I'd like to read my following opinion piece. This November, Rhode Island voters will be asked if they want to hold a constitutional convention in 2015. The Rhode Island state constitution requires that this question appear on the ballot every decade. The last time state voters were asked, they rejected holding a constitutional convention, and with good reason. While supporters of a con often claim it can reform government, history demonstrates that the issues raised often have little to do with ethics or reform. Instead, ballot questions coming out of the convention could erode access to a range of individual rights that Rhode Islanders strongly support. Back in 1986, while I was serving as medical director for Planned Parenthood of Rhode Island, I found myself the object of a great deal of hurtful personal criticism. It was a dangerous time when large groups of anti-abortion protesters stormed women's health centers all across America, and when providers like myself took enormous personal risks, and some were even murdered, as they delivered important and completely legal reproductive health services to women who needed them. But in Rhode Island, a 1986 Constitutional Convention narrowly approved by a single vote a ballot questions requiring that our state constitution declare that life begins at conception. Clearly, this language would have flown in the face of Roe v. Wade, the 1973 Supreme Court decision legalizing abortion. It could also have impacted access to a range of reliable, safe, and common contraceptive methods opposed by those who also object to legal abortion. A host of concerned advocacy groups like the ACLU of Rhode Island and Rhode Island Now, along with Planned Parenthood of Rhode Island, and many concerned individuals and medical and legal professionals worked tirelessly to educate voters about the dangers of this provision. Ultimately, Rhode Islanders voted by a 2-to-1 margin not to approve this question, but only because of an expensive, time-consuming effort. And despite this important victory against extremism, a second anti-abortion amendment passed by the convention, one that was not as obviously sweeping, was approved by the voters and remains in our Constitution to this day. Some claim that a constitutional convention is a purer form of democracy, but really delegates to a con are often political insiders, including even legislators' families and family members, chosen in an off-year election when voter turnout is very low. And because these delegates will not face re-election, they don't need to be accountable to voters. Only 18% of the electorate elected delegates to the last convention. In states across the country where ballot questions are a common feature on Election Day, controversial and divisive issues have become regular fodder for expensive campaigns promoted by special interests. Campaigns that attack gay rights, civil rights, immigrant rights, affirmative action, the right of workers to organize, even gun ownership rights have all become subjects of state ballot questions. The risks to our minority communities and to women in these situations are enormous. Necessary legal challenges to these policies are costly and can take years to resolve. While some risks are constant, others have grown since 1986. Today, wealthy out-of-state political donors can see small states like Rhode Island as inexpensive proving grounds for issues they want to promote more broadly. As a result of numerous court decisions, unlimited amounts of money can be spent by these groups to prove their points, and they focus over and over again on ideologically driven social issues. Finally, a constitutional convention isn't free. 30 years ago, it cost Rhode Island almost $1 million to convene it, and to pay for the ballot questions that resulted. Estimates that it could cost 4 to 5 times that much to convene a convention in 2015. With everything else we Rhode Islanders want and need, where would that money come from? What important programs or services, or highway repairs or disaster response would take a hit to convene a con-con? At a time when half of legislators are running for re-election unopposed, voter activism and greater participation in the electoral process would be a better medicine than the illusion of reform through a con-con. Real reform needs to and can occur at the State House with the right leadership. Let's not be dazzled by the promise of a bright, shiny object, the false hope of a constitutional convention. Instead, let's hold our elected officials responsible for the ethics reform we all know is needed, and they can and should deliver. A specific suggestion that I would have for the members of the Commission as you prepare your report would be to estimate the actual cost of the special election that would elect the delegates, because the voters need this information in order to make an informed decision this fall when the question is asked. We have a potential $400 million structural deficit in the next few years. And casino finance economies all throughout the Northeast are seeing their revenues down. We're seeing casinos going belly up in Atlantic City. And our state budget is so directly tied to casino gambling that every dollar that we spend should be carefully scrutinized. Engaging in an exercise like the con-con will necessarily affect those most vulnerable who depend on government services. A fiscal statement calculated independently should be an essential part of the question whether to hold a convention. If not in the language of the question, at least it should be included as part of any educational outreach or printed informational materials developed by the Secretary of State. I thank you for the opportunity to address this commission.
Are there any questions or comments for Dr. Rodriguez? Certainly proceed.
Just two questions. We were talking about your concern of the Constitutional Convention back in 1986 about the issue of the right to abortion, correct?
Mm-hmm. Yes.
Okay. Now, if I recall, in 1986, the ballot, the constitutional amendment went down by a 2-to-1 margin approximately?
Yes.
Okay. And the second is, even if it had been adopted, it would have been in conflict with the interpretation of the U.S. Supreme Court as to the right to abortion, correct?
That's correct.
Okay, thank you.
Are there any other questions or comments? I would just say, I know that the fiscal offices of the General Assembly are right now in the process of trying to get an estimate of what the cost of the Constitutional Convention will be, and as soon as we get it, obviously we'll give it to the committee members to get it disseminated out there. The next witness we have is Stephen Alquist. Good afternoon and welcome.
Thank you. My name is Steve Alquist, and I'm the president of the Humanists of Rhode Island. My group voted overwhelmingly to be a part of Citizens for Responsible Government, a coalition opposed to holding a constitutional convention because we are dedicated to preserving and expanding human rights. In studying the effects of past constitutional conventions, both here in Rhode Island and in other states, we see little in the way of positive outcomes and much that gives us pause. In our view, constitutional conventions become the tool by which legislation is advanced that seeks to curb or reverse hard-won civil rights. It opens up battlegrounds on contentious issues to the benefit of no one save for the advertising companies that stand to rake in millions of dollars as various PACs flood our state with flyers and television ads about the pros and cons of issues our state has already deliberated on and decided. Right now, one of the single biggest issues facing our democracy is the power of big money to influence elections. Holding a constitutional convention is tantamount to putting a for sale sign on the Rhode Island state constitution. The battles engendered will be costly, not only in terms of money, but in terms of the quality of discourse. Do we really need to relitigate marriage equality? Should we be putting basic human rights up to a vote? Do we want to be spending the next 10 years in court untangling the mess that certain legislation is bound to create? Thank you for your time and attention.
Are there any questions or comments for this witness? Thank you.
You're welcome.
The next witness we have is Barry Schiller. Good afternoon and welcome.
Thank you, and thank you for your time. I'm only speaking for myself, I want to be clear, not for an organization, although I have organizational affiliations. I hope the Commission will report that this is an opportunity to strengthen democracy, and especially if voter initiative that I favor, which is my biggest hope coming out of the convention, is also approved. And I think we need to strengthen democracy. Rhode Island is not working so well right now, and it's not just the high unemployment. It's public disillusion with government. It's public cynicism. We're rated as one of the most unhappy states. People are very negative about our government, and that takes a toll on our quality of life, our economic development. And I believe that we need to improve civic engagement, and this is an opportunity to do that. I think that there is legitimate concern about civil rights. I'm a proud member of the ACLU, and I would defend their right to disagree with me. The fact is, though, that I don't think at these times and the nature of Rhode Island that there's much threat. That's my judgment. I've lived in other states, New York, California, Florida, Ohio, and briefly in Texas and Colorado. And my judgment is the nature of Rhode Islanders, although there are a few that hate minorities and immigrants and women, that's not Rhode Island. Rhode Island is a good place because people are relatively tolerant. I don't think we need to worry about it. On the other hand, a constitutional convention, and if voter initiative came out of it, is an opportunity to expand our human rights. The right to an education, the right to basic health care, the right to, for the terminally ill. Would the Assembly deal with some of those things? I think this is an opportunity for the public to move that kind of concern forward. Civil rights is not the only issue that might come out of it. Another reason Rhode Islanders are disengaged from civic activity is the perception of corruption. This is an opportunity to strengthen anti-corruption laws and ethics laws. I think we need to do that. I don't think the Assembly people are bad people, but nobody likes to have oversight, like an ethics commission oversight over themselves, and to voluntarily add to the ethics commission power is just not in the nature of how things work. Same thing with, I'm not sure what I think about line item veto for the governor, but I do think that it's the nature of the General Assembly not to want to give up power to the governor. It's not because they're bad people, it's just the way things work. I think we could, if we had a constitutional convention, we could have a legitimate debate about where there might be a consequence on line item veto for the governor. I hope we have that debate. I don't think we'll have a serious debate in the Assembly. The same thing with General Assembly rules. As I understand the Constitution now, the rules that give us, for example, roll call voting results, they're not in the Constitution. They're just Assembly rules. Another Assembly could abolish them, and we wouldn't have a right to know how people voted. The rules could be suspended, and all those midnight sessions the last 2 nights, believe me, the public is very cynical about that. Again, not because we think there's bad people trying to get things done, but it's a bad process, but it's consistent with the Assembly establishing and suspending its own rules. A constitutional convention might have a chance to address this kind of thing, and this is the kind of thing Rhode Islanders want so that we can have more confidence in their government. I happen to believe personally in activist government that helps the needy, protects the environment, builds infrastructure, provides education, and so on. And all these negative things are getting in the way of getting that accomplished. And finally, I'll say I'm a longtime member of the pro-choice community. And frankly, we're only one Supreme Court justice away that the next president might pick from overturning our federal rights on that issue. And I asked the pro-choice community, who would they rather have in charge in Rhode Island if that should happen? The Assembly as it is now, or the voters and the people of the state of Rhode Island? I personally my judgment is, from a pro-choice perspective, I'd rather have the public have a check on the Assembly if necessary. And a constitutional convention and voter initiative gives us a chance to do that. Otherwise, we have no redress. Thank you for your time. I appreciate the time that you people are putting in on this on a nice summer day. Thank you.
Are there any questions or comments for this witness? Rep.
Thank you, Mr. Chairman. Mr. Schiller, great job. I mean, you know, you really spoke from all different sides of the aisle. But my question is, you know, we hear the pros and the cons and how, you know, the sky could be falling and God forbid that we have people want something like this, that it could have negative consequences of immigration or women's rights or reproductive or gay rights or whatever the case might be. So how do you propose that we weed out the good from the bad that can come from something like this?
I think we have to make a judgment about whether there's more potential benefits than there are potential risks, and obviously reasonable people could disagree. I look around at Massachusetts, a very similar state that does have voter initiative, and I don't think anyone could argue that there's a lot of anti-women, anti-gay, anti-immigrant, anti-black, anti-Jewish, or any of those things going on in Massachusetts where the people do have some rights. And I think Rhode Islanders are the same. I have confidence in Rhode Islanders to defend each other. And also I believe the times have changed a bit. With Snowden revelations, the public is more worried about protecting their rights rather than taking them away, as maybe after 9/11 or things like that, or the high crime of the 80s. So I just make a judgment, it's my judgment, that it's more important to strengthen democracy, and I hope that will be the overriding message of the Commission, that this is an opportunity to strengthen the democratic spirit in Rhode Island.
And for the record, I don't know about any legislator that's in love with the 3 a.m. sessions, because my mother was right. Nothing good happens after midnight.
Good for you.
Representative.
Thank you. Thank you very much, Mr. Schiller, for your testimony. And you're spot on. Civic engagement is certainly important, and yourself and other people have raised the judicial reform, the ethics reform, and voter initiative as important issues. But to what my colleague's talking about, isn't it true, though, that once a convention is called, although we're listening to the testimony of the people of Rhode Island, and this commission will frame some suggestions, but that convention, once it's called, those delegates will set their own agenda. So whether it's, as you say, social issues or gun rights being taken away, I mean, there's no control as to what percolates at a convention, correct?
Yeah, you're absolutely right. And again, you have to make a judgment whether that's a real threat or just, you know, or there will be a few people that will want to do those bad things, but you have to make a judgment about where Rhode Islanders are. And my judgment is that those things won't fly. They're not flying, as I said, in neighboring states where people already have some of those rights to do that. I just don't think things are working that well, and this is an opportunity to improve it. And I know that you're in the Assembly, and I don't mean to criticize the people in it, because I know a fair number, having been a volunteer lobbyist a bit, and I know most of them really do want to do the right thing. But it's just the nature of things that it's reluctance to give up power. There's so many ways that happens. You know, there's legislative grants. You know, is a thing that has. I mean, even within the Assembly, there's a need for democratic improvement, because there's so much power in just a couple of leaders, and things like legislative grants, which are legal. I mean, things like that could be addressed, perhaps, so that there's more democracy within the Assembly. Mm-hmm. I guess I segued from your question a bit, but
it's okay. But again, you get to the point that anything could percolate and anything can come out. Thank you very much.
But as has been pointed out, we still have the U.S. constitutional protections, but I think fundamentally we have the protections of the decency of the Rhode Island people.
And it would be wrong for the voice of the people not to be heard. Thank you.
Thank you.
Thank you, Chairman.
Are there any other questions or comments? Ms. Jones.
This is really just a comment. I think there has to be some distinction between what's appropriate to be taken up in a constitutional convention versus it being a fix-all for everything. And So that is just something in my own mind that I've been trying to sort out. But I think that the expectation has to be what is appropriate to do through the Constitution rather than through just regular legislation.
I just want to say I agree with you, and that's why I kept mentioning voter initiative, because some of the things I was saying could only come that way, not through the convention itself. But see, voter initiative is another power the Assembly won't give up because it takes power from the Assembly to propose things and gives some of that power to the people. That's something that they're not going to approve, at least from all I've pursued that particular issue. It's basically on the back burner now because of the nature of people holding on to power. But voter initiative gives us a chance to do the catch-all things, such as, for example, rights of the terminally ill, as happened in Oregon.
Thank you.
Are there any other questions or comments? Mr. Frye.
Quick comments. First, thank you for bringing up voter initiative. I think, as you noted, it's in Massachusetts. It's worked, and it has not caused significant amounts of problems. Two, thank you for pointing out that the protections of the U.S. Constitution will not be impacted or affected by whatever comes out of this state constitutional convention. And three, thank you for pointing out that in the end, it's the voters that decide what is approved and what is not approved, and that the voters of Rhode Island have shown for a great period of time a great deal of decency in regards to these types of issues and sensitivity, and I thank you for bringing that out as well.
And I thank you.
Are there any other questions or comments for this witness? Thank you. We do have one more witness signed up, Stephen Brown. I see a number of other people in the room. I don't know if they want to speak, but if you do, when Mr. Brown starts his testimony, if you can just come forward and fill out the witness sheet. Good afternoon and welcome, Mr. Brown.
Thank you, Chairman and members of the Commission. I appreciate your indulgence in letting me speak a second time. I just wanted to briefly address a few issues. I gave a general overview at the first hearing, and there's one particular issue I want to address in light of the testimony that you just heard, and that has to do with strengthening democracy. The ACLU strongly supports strengthening democracy, but we have a representative democracy, and there's a very big difference. A constitutional convention, by its very nature, first of all, does not allow for the deliberative process that occurs through a legislative process. The Constitutional Convention meets for a few months, they decide something, they vote on it, and that's it. In the legislative process, sometimes things take a lot longer, and sometimes it can be painfully slow, but constitutional issues deserve to be given careful consideration. And it goes through two bodies, not one, and I think that sort of slowing down is extremely important when you're talking about amending our Constitution, because it's not easy to unamend it once it's done. And I think that's a benefit. It's not a disadvantage to have those safeguards in place, which are missing by a constitutional convention. The other aspect that I think is very critical, as much as I also respect the voters and their interest in voting right, in learning about the issues, what we saw happen in 1986, and I'm confident, unfortunately, what we would see happen in 2016, if there were a convention, is the overload that individuals have to deal with. The 1986 convention proposed 25 constitutional amendments. 25. There were so many, they had to be bundled into 14 questions on the ballot. The actual language of the constitutional questions didn't appear on the ballot itself because obviously that was too much. And we all know the devil is often in the details, whether it's a statute or a constitutional amendment. So voters were faced in the matter of a few months of supposedly learning, understanding, and appreciating what 25 different constitutional amendments really did, what they meant, whether they were good, whether they were bad, and then attached to that, and I think I mentioned this at the first hearing, because of the bundling of the questions, the decisions became even more complex. I believe I mentioned the ACLU itself opposed a ballot question in 1986 that added a free speech clause to our state constitution, because another question in that bundle was the one of the anti-abortion amendments that Dr. Rodriguez talked about. I don't think that the outcome is necessarily the best or the right way to amend a constitution in that way. We're very concerned that if you have a convention, it's almost inevitable that you will see 25 questions. I mean, that's what they're there for. They're there to propose amendments to the Constitution. So just that process itself is of great concern to us. And then when you add to that fact the concerns you've already heard expressed about the anti-civil rights measures that we believe are likely to come out of it, we are deeply troubled by the process and the whole notion of having a constitutional convention. And for those and many other reasons, we oppose it. I'll be glad to answer any questions.
Are there any questions or comments for Mr. Brown? Ms. Jones?
What do you foresee perhaps in the money that's now available for lobbying and advocacy around these issues, and even for delegate selection, which is very different from what has been available previously? What do you see as, do you see that as a concern in making a constitutional, the election of delegates in the convention itself, and then lobbying for amendments, a different situation than it was previously?
I definitely do. I don't think there's any question that Rhode Island would see a tremendous influx of out-of-state money, whether it's to help in electing delegates or, more importantly, to guide the issues that the convention votes on and ultimately that the voters vote on. I want to give you a staggering figure, and that's $934 million. That is the amount of contributions that were made to ballot measure committees across the country in 2012. This is now a big business, and we support the court decisions that say people should have the right under the First Amendment to contribute as much as they want to these types of referenda campaigns. But I think we're kidding ourselves if we think that somehow Rhode Island is going to be immune from that type of out-of-state interest in pushing their own issues, and I definitely think that's something that needs to be put on the table. This will not just be Rhode Islanders deciding these issues. There will be a lot of out-of-state people very interested in trying to guide the decisions as well.
Mr. Frye?
Just a few questions. You brought up the issue of bundling amendments that include different types of topics. Hasn't the General Assembly in the past had amendments that proposed to the public that included bundling of different concepts? For instance, in 1994, they proposed an amendment that downsized the General Assembly but at the same time increased its pay. So in the same sense, for instance, I was a voter at the time. I was kind of torn about the issue because I wanted a smaller size assembly, but they didn't want to give them increased pay and free family health care. Would you agree that bundling amendments do occur by the General Assembly?
Not the way they do at a constitutional convention. No, I would not agree with that. I mean, you may be able to choose one or two amendments that the General Assembly has done and parse them into a couple of issues, but again, it's nothing like the 1986 convention, which didn't have two or three. Some had 5 or 6 amendments tied together.
My question was, is it possible? The General
Yes.
Assembly, yes. Thank
Sure.
you. When you indicated that outside that money can influence a constitutional convention or issues raised by a constitutional convention, campaign money. Hasn't campaign money also influenced other types of ballot issues in this state put forward by the General Assembly, for instance, casino?
Yes.
Thank you. Do you agree that it is good, and let me ask you this is a subjective question, have good amendments come out of a constitutional convention in the past?
I'm only familiar with the 1986 convention, and I would say nothing that passed out of the 86 convention was worth it. No.
Not the Ethics Commission amendment?
No, I mean, that's an interesting one. The Ethics Commission amendment was one of the few so-called good government reforms that passed the convention, and here we are 30 years later complaining about that the 1986 convention language we need another convention in order to correct the language that was passed in 1986.
Would you agree that the reason we are trying to change the language in the amendment is due to a Supreme Court decision that was enunciated at the end of the last decade in regards to Senator Irons?
No, I would say it's because of ambiguity in the language that was passed by the 86 convention.
Okay, thank you. It's legal interpretation.
Are there any other questions or comments?
Thank you.
Does anyone else present wish to speak? With that, we do have a meeting on Thursday at 3:30, and this meeting is concluded. And thank everyone for coming out today.